Welcome to UCL, to the Faculty of Laws and to the Judicial Institute. We have a virtually packed audience this evening, with the emphasis on virtual, of course. My name is David Ormerod and I'm the co-director of the Institute. The Judicial Institute is the UK's only centre devoted to research and training and teaching engagement with the judiciary. It was established in 2010 in consultation with the senior judiciary in order to provide independent research about the judicial system. And it's my great privilege to introduce our speaker this evening, the Right Honourable Lord Burnett of Maldon, the Lord Chief Justice of England and Wales. He is, of course, known to those of you who work in the criminal justice system. Having been called to the bar by Middle Temple in 1980, he was junior counsel to the Crown, common law from 1992 to 1996. He took silk in 1998. His practice developed to focus on public law and administrative law and became, as you might imagine, a catalogue of complex and demanding cases. There were numerous high-profile public inquiries, King's Cross Fire, the Guildford Four and numerous others, and Lord Burnett also appeared in many of the early cases interpreting the Human Rights Act, including several in the House of Lords. I'm confident my class of students studying human rights will be familiar with those. After appointment to the Queen's Bench Division of the High Court in 2008, he served as the presiding judge on the Western Circuit, and he was elevated to the Court of Appeal in 2014. He was appointed as the Lord Chief Justice in 2017. And I suspect that Lord Burnett will be familiar to a wider public audience than many of his predecessors. He's had a substantial public profile throughout the pandemic, and it fell to him to make that unprecedented decision in March this year, pause all jury trials. I'm not sure whether there is an instruction manual provided on appointment as Lord Chief Justice, but if there is, I doubt that the guidance on that features in it. Of course, we got jury trials up and running very quickly by comparison with many other jurisdictions. Given the distinction of our speaker, it's no surprise that we have such a huge audience this evening. Over 400 are logged on, along with the handful of us here socially distanced. I feel confident also that the numbers are greater because of the topic Lord Burnett has chosen for his lecture. Sentencing is a topic that always seems to excite interest, but divide opinion in equal measure. There's no doubt that sentencing offenders is a complex and demanding task. It represents a critical point in the criminal process, and of course, the judge plays a vital role. Without more, may I invite the Lord Chief Justice to deliver the 2020 Judicial Institute lecture, Sentencing the Judge's Role.
Well, David, thank you very much indeed for that introduction. It's a pleasure to have been asked to give this year's Judicial Institute lecture, the first since Professor David Ormerod succeeded Professor Dame Hazel Genn as co-director with Professor Cheryl Thomas. Both have a wealth of academic and practical experience in judicial matters, which will ensure that the Institute remains at the heart of the study of the judiciary. Thank you for asking me. I want to speak this afternoon about sentencing. Across the magistrates and Crown courts, thousands of people are sentenced every day for crimes ranging from minor motoring offences or failing to pay a TV licence to serious violence, sexual offences and homicide. Public and political attention focuses on crimes sentenced in the Crown Court. That's because the Magistrates' Court deals only with summary offences where the penalties provided by Parliament are limited to a fine or a very short term of imprisonment, or offences which could be tried or sentenced in the Crown Court, so-called either-way offences, but for which the limited sentencing powers of the Magistrates' Court are sufficient. The Crown Court deals with tens of thousands of either-way offences each year, as well as the more serious cases, which can only be tried on indictment in the Crown Court. Now, were the mythical alien to arrive on Earth, and, I grant you yet more improbably, take an interest in sentencing in England and Wales by reading the newspapers and dipping into the more noisy parts of our online media, it would soon get the impression that sentencing has got softer in recent years. It would read about, quotes, wet liberal judges being soft on criminals, close quotes, and wonder why criminals convicted of serious offences were getting more lenient sentences than they used to. Then, our alien visitor might seek some other sources of information, and if possessed of a brow, it might become furrowed. There is a difficulty with this narrative. It is a myth. Here are some facts. In 1993, the prison population was a little over 44,000. It is now a little under 80,000. In December 2009, the average length of all custodial sentences was 13.7 months. In December 2019, it was 18.9 months. For cases that could be dealt with only in the Crown Court, the average was 16.5 months in 2009 and 21.4 months in 2019. There have been further increases since last December. The latest Ministry of Justice figures show that the overall average has risen to 19.6 months, and for indictable-only offences to 22.2 months. Now, the average length of the minimum term that a person convicted of murder and sentenced to life imprisonment must serve before the parole board can consider release on licence had risen from 12 and a half years in 2003 to 21.3 years in 2016. There are many reasons for these increases, but there is no doubt that in recent decades, sentencing levels have increased, not reduced. Sentencing has been described as part of the criminal process where the court, quotes, has a free hand within the limits laid down for the offence in question, close quotes. That captures both the evaluative and discretionary element in sentencing, and also that there are limits and structures within which judges operate. The starting point for sentencing is the statutory framework provided by Part 12 of the Criminal Justice Act 2003. Subject to some limited exceptions, a court sentencing an adult offender must have regard to 5 purposes of sentencing. The 5 purposes are listed, but without any priority or specific weight being given to each. That, of course, will vary from case to case. They are the punishment of offenders, the reduction of crime, including its reduction by deterrence, the reform and rehabilitation of offenders, the protection of the public, and the making of reparation by offenders to persons affected by their offences. These objectives have a long history. Plato, for instance, emphasised the importance of punishment as a means to promote deterrence, both of offenders and of the public. Closer to our time, Jeremy Bentham understood the aims of sentencing as deterrence, rehabilitation, and incapacitation, the last being what is now referred to as protection of the public. We ought to be clear that it is no purpose of sentencing to exact vengeance upon an offender. A different approach is taken to sentencing young offenders, individuals under the age of 18. The principal aim of the youth justice system is to prevent offending or reoffending. Sentencing must take account of the welfare of the offender, as well as consider punishment, reform and rehabilitation, protection of the public and reparation, as in the case of adult offenders. Again, there are limited exceptions where these principles do not apply. The different approach to young offenders stems from the long understood view that youths make mistakes that an adult would not be expected to make. Children and young people are immature, often more easily led and influenced than adults, and are still developing. Their brains are developing. Youth and immaturity are reflected in the statutory scheme for sentencing those under 18, and youth and immaturity play an important part in deciding sentences for those in early adulthood when compared with true adults. Parliament has set the overall structure. It also sets the maximum sentence available for all but a small number of common law offences. It requires judges to have regard to sentencing guidelines. At the heart of the sentencing process is a statutory provision which few outside the law appear to have heard of. A court must not impose a custodial sentence unless it's of the opinion that the offence is so serious that neither a fine nor a community sentence is justified. If it is of that opinion, the sentence must be for the shortest term commensurate with the seriousness of the offence. Parliament's clear intention is that sentences of imprisonment, even suspended sentences, should be avoided unless nothing else will do. There is nothing new or unusual in this. It's a statutory requirement that has its roots in the earliest of the Anglo-Saxon sentencing codes, and one that, with the variety of sentencing options now available, enables judges to ensure, consistently with Parliament's intention, that sentences are just and proportionate to the crime. It is Parliament that specifies what period of any sentence must actually be served by the prisoner. Judges have nothing to do with that and take no account of the ins and outs of early release provisions when determining a sentence. It is well known that Parliament has specified that most prisoners serve only half of the sentence imposed by the court before they're released on licence, subject to recall if they reoffend or breach conditions, although in some circumstances the proportion is 2/3. And the position is changing because there is recent legislation affecting some sentences. While these statutory purposes shape how judges approach sentencing decisions, in all cases, the court determines a sentence by taking into account a series of factors. In all cases, magistrates and judges must consider the culpability of the offender, together with the harm caused by the offending, and thus assess the seriousness of the offence. In doing so, aggravating and mitigating factors are important. Aggravating factors, previous convictions, breach of trust, and so on, increase the seriousness of the crime and the sentence. Mitigating factors, such as the offender having no previous convictions, their age, mental health concerns, remorse, etc., have the opposite effect. I should pause here to note that the seriousness of the offence does not simply play a role in determining the length of a sentence. Courts may impose a range of sentences. At one end of the spectrum are absolute or conditional discharges. At the other, life sentences. In between, there are fines and community sentences with a range of conditions attached, such as curfew or work, through suspended sentences of imprisonment, an immediate sentence of imprisonment for a fixed term, and then extended sentences. There is now a bewildering range of orders that may be made as part of the sentencing process. Importantly, the court's assessment of these core factors will often determine what type of sentence is imposed, particularly when considering cases on the cusp between fine and community sentence and custodial sentence, and so on. Well, how do judges apply this framework? That takes me to the sentencing guidelines. They're issued by the Sentencing Council, which was established by Parliament in 2009. It is required to provide guidelines for different offences, which judges must follow, except where it is in the interests of justice not to do so. Its membership covers a wide range of interest groups. It develops guidelines through a transparent process and after wide consultation. In developing the guidelines, the Council is enjoined to promote consistency, to have regard to the impact of sentencing decisions on victims of offences, to the need to promote public confidence in the criminal justice system, and also the cost of different sentences and their relative effectiveness in preventing reoffending. Prior to the creation of the Sentencing Council, the earliest attempt at providing help to sentencing judges of which I am aware were unofficial, judicially created guidelines given to judges on appointment during the early part of the 20th century, although they were never published. From the early 1980s, the Court of Appeal increasingly laid down guidelines in the form of judgments, but it was still relatively rare for the Lord Chief Justice of the day to deliver guideline judgments. The guidance was broad, and by the late 1990s, the judgments had covered only a small proportion of offences. The Sentence Advisory Panel was created by statute in 1998 to make recommendations. This was followed by the creation of the Sentencing Guidelines Council in 2003, which produced guidelines to which the courts were required by statute to have regard, a weaker requirement than now applies. The intention behind the sentencing guidelines is to ensure that there is far greater transparency and hence understanding of the range of sentences that judges can be expected to give for specific offences. This greater transparency is reinforced by a statutory requirement that judges must set out their reasons for their sentencing decision in open court and in ordinary language, together with its effect. They also require judges to identify any applicable sentencing guidelines. If the judge decides that it is in the interests of justice not to follow the guidelines, he or she must also explain why. The reasons need not be elaborate, indeed should be short and in straightforward language, so that the defendant and public understand why the sentence was imposed. The guidelines don't just set out the range of possible sentences, breaking down each offence into categories with fluid boundaries. They also provide the framework for determining the sentence. They set out a stepped approach dealing with culpability and harm, aggravating and mitigating factors, and so on. The guidelines explain that judges are required to take account of any reduction to the sentence for a guilty plea. Those reductions are themselves the subject of a guideline and range from 1/3, when a guilty plea is indicated at the first opportunity, to only 10% if it comes at the beginning of a trial. Yet, as the Court of Appeal has repeatedly explained, the guidelines are not tramlines. A judge is free to go outside the guidelines for good reason. I should add that a further and very welcome addition to the sentencing process has just been introduced. That is the statutory sentencing code. It was the product of a great deal of hard work by the Law Commission, a project led by David Ormerod. It sets out clearly and comprehensively the law concerning sentencing by bringing all statutory material into one place. This is a huge advance. Previously, the law affecting sentencing was scattered across a multitude of statutes, making it difficult for judges, magistrates, and practitioners alike to work out what applied in any given case. That resulted in many mistakes, which had later to be corrected in further hearings or appeals. That will now largely be avoided. Today's approach to sentencing will, of course, differ from the past. As society changes over time, so do approaches to crime and punishment. At one time, imprisonment was primarily a means of pre-trial detention. It was famously used as a means to compel payment of judgment debts. Imprisonment as a form of sentencing really came into its own during the 18th and 19th centuries. Two things lay behind that evolution. First, the decline in the use of capital punishment for a wide variety of offences. Secondly, the initial replacement for capital punishment with transportation, and for a short period the prison hulk, both of which fell away. These historic shifts left imprisonment as the primary focus of sentencing policy. The increasing importance of prison within penal policy was not the only development. As it became the centrepiece of sentencing, alternatives were also being delivered. Alternatives that reflected an acceptance by policymakers in the past that different approaches to sentencing were needed to take account of different types of offender. A point the Gladstone Committee on Prisons reached in 1895. For it, imprisonment was too broad a brush. It recognised that, quotes, habitual criminals, habitual drunkards, mentally disordered offenders, first offenders, young prisoners, women with infants, remand prisoners, and debtors required different approaches. Recognition of mental disorder and illness and the need for differential treatment can be seen from the Mental Deficiency Act 1913 and the Infanticide Acts of 1922 and 1938. The former was based on an understanding that prison was not always appropriate for those convicted of crime who were mentally ill. That approach has been carried forward through into contemporary legislation, which provides for different disposals for some who are mentally ill, and more generally is recognised in the recent guideline from the Sentencing Council. The Infanticide Acts acknowledged that murder was not an appropriate charge for women who had suffered mental illness consequent upon giving birth, despite all the normal ingredients of murder being present. The shift to greater differentiation in the treatment of some categories of offender ran in tandem with an increase in alternatives to imprisonment itself. Probation was introduced on a voluntary basis in the 19th century and then put on a statutory footing in 1925. Borstal institutions for young offenders, the stated aim of which was to train and rehabilitate, were introduced in 1948 and then replaced in 1982 by youth custody centres and now young offender institutions, together with secure accommodation for those aged 15 and under. The suspended sentence entered the picture in 1967. The first community sentence was handed down by Mr. Justice James in 1973. From 1998, antisocial behaviour orders became available. A wide range of conditions can be attached to community and suspended sentences. The 21st century has seen the introduction of injunctions and criminal behaviour orders under the Antisocial Behaviour Crime and Policing Act 2014. When we add in the use in some cases of restorative justice measures, we can see a broad evolution in the approach and sophistication of sentencing. I do wonder whether modern views of current sentencing practice may be determined by a misplaced view of the past, and not only the recent past. Where crime and punishment are concerned, it's often easy to imagine that the past took a stricter and tougher approach to criminal sentencing. The truth is more complex. What sentences, for example, would be attached to an Offences Against the Person Act if it were passing through Parliament today? Our Victorian forebears created two offences with precisely the same harm in the still in force 1861 Act: wounding or causing grievous bodily harm. One, Section 18, also carried the requirement for the offender to intend to cause harm of that seriousness. The other, Section 20, did not. The difference in available sentences? Life imprisonment for Section 18, but only 5 years for Section 20. The Victorian Parliament considered that culpability, not harm, should have the dominant voice. Now, human nature being what it is, similar crimes are committed in every jurisdiction in the world, and each has its own approach to sentencing. There is a rich study in international comparative criminal justice. Some countries sentence more severely than England and Wales. The United States, for example, at least in most states, and some in Eastern Europe. No comparisons are exact, but it's nonetheless interesting to glance at the position in other mature democracies. Time allows no more than a glance at Germany, Norway, and Australia, alongside England and Wales, for 3 serious offences. First, the approach to possession with intent to supply a kilogram of a Class A drug. In England and Wales, the maximum sentence is life imprisonment, but after a trial in the Crown Court, the offender might well expect to receive a sentence of about 11 years imprisonment. In Victoria, in Australia, a broadly similar approach is taken. The maximum penalty is also life imprisonment, but an offender in a typical case might expect to receive a sentence of 8 to 9 years imprisonment. A comparable offence in Norway would attract a sentence within the range of 3 to 15 years imprisonment, with 4 years being the starting point from which specific aggravating and mitigating factors would then be taken into account. A similar offence in Germany would attract a sentence of between 1 and 15 years imprisonment. For a 1 kilogram amount of heroin, an offender would typically expect to receive a sentence of between 4 and 8 years. What about grievous bodily harm with intent? As I've said, under Section 18 of the Offences Against the Person Act 1861, the maximum sentence is life imprisonment. Where someone stabs another with intent, they might expect to receive a sentence of imprisonment in double figures. A comparable offence in Victoria, Australia, intentionally causing serious injury, has a maximum sentence of 20 years imprisonment. An offender might expect to receive a sentence of 6 to 7 years imprisonment. In Norway, a comparable offence, aggravated bodily harm with a knife, attracts a maximum of 15 years. A typical sentence may, however, start from 3 years imprisonment. A similar picture emerges in Germany, with the minimum sentence being 1 year and the maximum 10 years imprisonment. Then in England and Wales, rape carries a maximum sentence of life imprisonment with a starting point of 5 years in the guideline for the least serious offences of rape. A sentence of 4 to 7 years would be expected. In Victoria or Australia, the minimum sentence is 25 years. In a case with no specific aggravating or mitigating factors, an offender would expect to be sentenced to 6 to 7 years imprisonment. In Norway, sexual assault involving intercourse has a minimum term of 3 years and a maximum of 15 years imprisonment, starting from a baseline of 4 years with no specific aggravating or mitigating factors. In Germany, the comparable offence has a minimum sentence of 2 years with a maximum of 25 years imprisonment. These 3 examples are not intended to suggest that the approach in England and Wales is any better or worse than that in Australia, Norway or Germany. There are both similarities and differences, but they do not suggest that the approach to sentencing these serious offences in England and Wales is more lenient than in other jurisdictions. Now, we've seen that judges are required to sentence according to statutory purposes. They are required to follow guidelines applying the statutory provisions now found in the Sentencing Code. Individual sentencing decisions will properly be tailored to the circumstances of each case. They will not be arbitrary. If judges or magistrates go wrong, appeals will put them right. Sentences in the magistrates' court are subject to appeal to the Crown Court. Sentences imposed in the Crown Court may be appealed to the Court of Appeal Criminal Division on grounds that they are wrong in principle or manifestly excessive. There is a corrective available to the Attorney General if she believes that a Crown Court sentence in a range of serious cases is unduly lenient. She may refer it to the Court of Appeal. The figures are interesting. Between October 2018 and September 2019, of the roughly 70,000 sentences imposed in the Crown Court, there were 3,356 applications for leave to appeal against sentence, and in the same period, 672 appeals against sentence were allowed. In the calendar year 2018, the law officers referred 140 sentences to the Court of Appeal. Of that number, 99 were increased. As the Solicitor General said in August 2019, when issuing those statistics, and I quote, "It must be remembered that in the majority of cases, the right sentence is delivered. 70,000 sentences were handed down at Crown Courts in England and Wales in this same year, and only around 0.1% of these were found to be unduly lenient, showing that in the vast majority of cases, judges get it right." Close quotes. Quite so. In 2019, only 93 cases were referred, of which 63 resulted in increased sentences. That too might surprise my alien visitor, focusing too much on social and broader media. I started by indicating that rather than sentences becoming more lenient over time, the opposite has in fact been the case. Well, there are various explanations for this. One has undoubtedly been the increase in minimum terms attached to sentences of life imprisonment for murder. The Criminal Justice Act 2003 substantially increased the starting points for the minimum term that a murderer must serve. Only after serving that term can the parole board direct release if they conclude it's safe to do so. Even then, the offender will remain on life licence subject to conditions and liable to recall to prison in the event of a breach of those conditions or reoffending. For an adult, the usual starting point is a minimum term of 16 years, but, for example, in cases where a firearm was used in murder or a murder occurred in the course of a robbery, the starting point for the minimum term is increased to 30 years. A 25-year minimum term was later introduced by way of amendment for murder involving a knife. A whole life tariff is appropriate for a range of the most serious offences of murder. The statutory minimum term starting points, albeit subject to upward and downward adjustment to reflect the circumstances of each case, led to the average increases I mentioned earlier. In consequence of the increase in minimum terms mandated by Parliament for murder, the Court of Appeal Criminal Division increased manslaughter sentences, increases which have followed through into guidelines from the Council. As the Council itself has noted, this resulted in average custodial sentences for manslaughter increasing from 5.4 years in 2007 to 8.8 years in 2017. Both Parliament and the judiciary have played a key role in increasing sentence length. These increases fed through into increases in the sentences imposed for attempted murder and serious offences of violence. Parliament has also increased the maximum sentences for a wide range of offences. For example, the maximum sentence for indecent assault on a girl aged under 13 was 5 years imprisonment until 1985. In 1985, this was doubled to 10 years. Since 2003, a sexual assault on a child aged under 13 has attracted a maximum sentence of 14 years. These increases are necessarily reflected in increases in the level of sentences set out in the guidelines. The Sexual Offences Act 2003 created maximum sentences which were often greater than those available for a like offence under previous legislation. Now, some academic commentaries suggest that the effect of the sentencing guidelines, by introducing a greater emphasis on consistency and proportionality, has resulted in sentences being adjusted upwards rather than downwards, and that the guidelines have, in specific cases, recalibrated the tariffs for sentences to increase those for offences where past sentences were viewed as being too lenient. To my mind, there has been a perceptible hardening of the public and political attitude to crime, particularly sexual and violent offending, which has resulted in a general shift in the balance between culpability and harm when determining sentence. Harm features more strongly than it did. This is perhaps best illustrated by the creation of new motoring offences. It has been an offence to drive carelessly for almost as long as there has been driving. But the consequences of that carelessness barely featured in sentencing, because the view was that those consequences were unpredictable and largely unrelated to the carelessness. Emerging from a junction, having not looked properly, might result in trivial damage to a passing car, or the death of a motorcyclist following the same momentary inattention. However dreadful the consequences, careless driving was a summary-only offence for which a fine and points, occasionally a disqualification, were the penalties. In 2008, Parliament created the offence of causing death by careless driving with a maximum penalty of 5 years imprisonment. The recent white paper on sentencing reform has again proposed a new offence of causing serious injury by careless driving, with the same sentence, following in the wake of the creation of an offence of causing serious injury by dangerous driving in 2012. The substantial uplift in minimum terms for murder was also an example of that phenomenon, with the consequences I have suggested. The judiciary has been sensitive to that change in legislative mood, and the council has also captured it in the guidelines. Judges approach sentencing within a clear statutory framework and in a structured way dictated by the guidelines. For many serious offences, custody, indeed a long period of custody, is the only available sentence. But for others, there are difficult decisions to be made about whether custody is appropriate, and if it is, whether a prison sentence can be suspended and on what terms, or whether a community sentence meets the justice of the case. In making those judgments, there is often room for more than one view. The entire process is structured to ensure that sentences are just and proportionate, within boundaries set by statute and guided by the guidelines. The evidence from the Court of Appeal suggests that judges are hitting the mark. Roughly 5% of sentences are appealed by defendants, less than 1% successfully. That means that many others have been advised that the sentence, although tough, cannot be said to be manifestly excessive. The figures of cases referred to the Court of Appeal by the law officers are very striking indeed. In 2019, as I've said, 93 were referred to the Court of Appeal, 63 successfully. But 577 sentences were considered by the Attorney General's office. So all bar 93 were winnowed out as not approaching the threshold for a reference. So quite apart from the bare statistics of the increase in the severity of sentencing we've seen in recent years, the tiny number of cases referred by the law officers and the smaller number still where sentences are increased punctures the myth of a soft judiciary not applying the law as ordained by Parliament when sentencing. Now, occasionally judges go wrong. We operate in public and state our reasons for making our decisions. Anyone is at liberty to disagree and can do so explaining why. But unreasoned or worse, ignorant or ill-informed criticism from apparently authoritative quarters tends wrongly to erode confidence in the administration of justice. That is corrosive and harmful. Of course, different views about matters of importance are a sign of a healthy democracy. Sentencing policy is a matter of acute interest to individuals caught up in the criminal courts, to commentators and academics, to the public and politicians. But let the debate proceed on fact and not misconception. By all means, have stimulating exchanges on whether either generally or for specific offences or type of offender, sentences should be tougher or more lenient. But please avoid the knee-jerk criticism of a judge for applying the law and guidelines when they produce a sentence that the commentator wishes was more severe. Thank you.
Lord Chief Justice, thank you very much. The Lord Chief Justice has agreed to take some questions, and we've had some pre-submitted and a few that have arrived in the course of the lecture. So I hope that we're both caught on the screen at the moment, this far apart as we are. Several of these relate obviously to themes that you've developed in the lecture, Lord Chief. Can I begin with youths? We had an anonymous question which was pre-submitted. Do you think that there should be individual sentencing guidelines for youths for each offence in the same way as there is for adults to avoid the complications in sentencing youths? And I think youth is being understood there widely to include under 18s and the 18 to 20s.
Yes. Well, there are two issues there. First, there is a very detailed guideline from the Sentencing Council on the correct approach to sentencing those who are under 18. And if a judge is on top of that guideline, as well as the guideline for the instant offence, then there should be no problem. The approach of the counsel has been to develop that general guideline to sit side by side with the other guidelines. So far as sentencing those between, shall we say, 18 and 21 or 22 is concerned, the nature of the statutory provisions appear to create a cliff edge, as it's called, between those who happen to have reached their 18th birthday at the time of sentencing. Now, there's been an increasing understanding in recent years, supported by a good deal of scientific study, that there really are differences between young people, including young adults of that sort, and mature adults. It's perhaps within all our contemplation, either thinking back to our own time as late teenagers and early 20s, or most of us know lots of people in that age category, that young people do stupid things that older people wouldn't do. And one of the most fascinating things has been the recent research, which has shown without doubt that the brain is still developing in a physiological way. Not only are youngsters continuing to mature, and that's why I suspect it is the experience of many of those who are listening, who are engaged on a day-to-day basis in the criminal justice system, that so much offending of all sorts is committed particularly by young men between the ages of 18 and 25. And there is reason to suppose that many do grow out of it. Now, in a series of judgments, not only mine, but also in particular Lord Judge, one of my predecessors, we've been trying to emphasise that youth and immaturity are important factors when considering appropriate sentences for people in that age range, particularly as the understanding of the differences between young adults and, if I can call them, real adults, has become clearer through the science.
That's very helpful and obviously very topical. I noticed that the Justice Committee recently, in its review in relation to sentencing of young people, also raised that issue
Yes.
for the Ministry. You mentioned there, and of course in the lecture as well, the significance of the Sentencing Council. And we had a question from David Lamming, who is a former member of Cornerstone Barristers in Gray's Inn Square. To what extent has the duty of the court to follow any sentencing guidelines which are relevant to the offender's case, unless satisfied that it would be contrary to the interest of justice not to do so? To what extent has that operated in practice, consciously or unconsciously, to constrain a judge passing what would otherwise be considered to be a just and properly merciful sentence? So to what extent are judges hamstrung by the obligation to follow the Sentencing Council guidelines? Has it constrained judicial discretion?
Well, I mentioned in my talk repeated observations from the Court of Appeal Criminal Division that the guidelines are just that and are not tramlines. I also mentioned that the categories that the guidelines create have fluid boundaries. And so repeatedly, the Court of Appeal has encouraged sentencing judges to make the sentence fit the crime and the offender. And so the guidelines shouldn't be having that effect. One thing perhaps I have noticed over the years is that it's quite difficult sometimes for judges to identify by how much an aggravating factor or a mitigating factor should operate to move away from the starting point and from the range of guidelines. And as a general observation, one of the points I would make is that in most of the guidelines there are not only set out statutory aggravating and sometimes mitigating factors, but also other indications of what they may be. And it's just, I think, a matter of accident that often the list of aggravating is longer than the list of mitigating. And so I have wondered from time to time whether a mitigating factor is given sufficient weight. And so if the underlying point of the question is, do judges feel that they need to be anchored to the starting point in the guideline? The answer is that all the authorities from the Court of Appeal suggest that they shouldn't, although there are occasions when one wonders whether that has been the case.
Excellent. And I raised in my introduction the impact of the pandemic, and of course you are keenly aware of that. We have a question from John Samuels, a retired judge who I'm sure you know well, president of the Prisoners Education Trust. He asks, given the recognition by the Court of Appeal Criminal Division of the impact of COVID on those in prison, which justified the suspension of what would otherwise have been an immediate custodial sentence in Manning, in the case of Manning, do you agree that some practical recognition of the conditions experienced by serving prisoners is now appropriate? Whatever the practical problems inherent in that recognition, if the executive omitted to concede this, would out-of-time applications to appeal individual sentences be justified?
Well, there's a lot in that question. I certainly wouldn't wish to be seen to be encouraging out-of-time applications for leave to appeal sentences. But as John Samuels has mentioned, very shortly after the first lockdown, as it's called, in March, I took the opportunity in the Court of Appeal to restate what is an entirely orthodox point of sentencing principle and practice, namely that in deciding whether to send somebody inside immediately, and also in deciding the length of any sentence, it is appropriate to take account of the impact of the sentence on the individual concerned, and also the impact of the sentence on those close to them. Now, in the early stages of COVID, the government was understandably very concerned to ensure that the prisons didn't become a hotbed of infection. And as it happened, they didn't. But one of the consequences of that was that prisoners were locked up in their cells for much longer than was normally the case. And ordinary visiting was also interrupted. And so, in indicating in the Manning case that those were factors that judges could take into account, I wasn't saying anything remotely controversial, nothing unorthodox, although one might have been forgiven that some thought it so, given the way it was dealt with. But as a general principle of sentencing judges and magistrates, of course, look at the impact of imprisonment on somebody, and it feeds through into other areas. I mentioned mental health as an issue that needs to be taken account of when sentencing. And the reality is that the impact of custody on some with mental health illness and difficulties is much more profound than it would be on somebody who was robust, if I can put it that way. And so those things are entirely appropriately taken into account when determining both type of sentence and, if there is a prison sentence, the length of sentence.
Thank you very much. I have a number of other questions. I'm going to combine two, if I may, in relation to the unduly lenient sentence scheme, which have been posed in the course of the lecture. One asks effectively whether or not the proportion, the number of unduly lenient sentences that are appealed is now too high, effectively, given that they were anticipated to be no more than 15 to 20 when they were introduced as a scheme, and now we're talking about the figures that you cited in the lecture. Does that volume suggests that it's morphed into a prosecution right of appeal rather than serving its original purpose of rectifying errors? And if so, and I'm combining two questions here, is it right to make to put some limit on that by requiring the appeal to be exercisable by the DPP personally, reducing the burden on the law officers?
Well, it's clear from the figures that I set out in the course of the talk that a very large number of sentences are sent in to the law officers. Now, most of those will be filtered by the Crown Prosecution Service, and so I suspect that the Crown Prosecution Service, although I don't know the figures, receives even more questions about whether a sentence might be referred by the Attorney General. But it's clear from the figures that the law officers have a rigorous system in place, which means that they don't refer sentences which it's clear are not going to be increased. So it's true that when this system was introduced, I'm trying to remember the precise year, David, you'll have it on your fingertips, I should imagine, but I think it's 25 years ago.
It is, it's 18.
The numbers started off rather smaller than they are now. But in fact, there's no general increase in the number, as some of the statistics I mentioned show. And if, broadly speaking, of those that are referred, something like 2/3 achieve an increase in the sentence, then it doesn't seem to me that that is too many at all.
And I'm going to corrupt somebody else's question here, which I'm taking as my chair's privilege. Other than in those cases of unduly lenient sentences, the Court of Appeal, of course, is constrained not to impose a harsher penalty than was imposed by the trial judge. Would you favour amendment to the Court of Appeal's powers to do that if trial judges face such a difficult exercise in imposing accurate sentences? Should the Court of Appeal have the opportunity to correct up as well as down?
So what you're envisaging is that a defendant appeals a sentence on the ground that it's manifestly excessive, and the Court of Appeal comes to the conclusion that it's manifestly not enough.
Exactly.
I wouldn't favour that. I really think that would be capricious, to be perfectly honest.
Very good. And one final one, I'm conscious of the time, you've been very generous with your time. This is an anonymous question, has the expansion of suspended sentences under the 2003 Act increased sentencing by being handed out as a tough community order instead of being applied to those otherwise facing immediate custody? So has it swept up rather than pressed down?
Well, it's a very interesting question, and one in respect of which there has been quite a lot of thinking and in the end work done. There was, as you'll remember, and again those who are online, who are deeply involved in the criminal justice system will know that there were problems in enforcing community sentences for some time because of difficulties in the probation services and so on, which have been put right by the government in recent years. And so there was at least a suspicion, although I don't recollect ever seeing any compelling evidence of it, that judges were imposing suspended sentences because they were doubtful whether a community sentence would be properly operated. But the Sentencing Council issued a guideline which dealt with that, because it made it quite clear that one starts at the top and works down rather than starting at the bottom and working up. And that was a guideline issued, again, I'm trying to remember precisely when, but 3 or 4 years ago.
Thank you very much. As I said, I'm conscious of the time and how generous you've been in dealing with those questions. Can I close by thanking you on behalf of UCL and the Institute? If our hypothetical alien visitor were tuned in now and who knows, he or she may be, of course. I'm sure they would be much wiser, the brow unfurrowed, but have a greater understanding of the law, how it's evolved, but also a greater respect for the judiciary and their rigour in the application of sentencing. Every sentencing exercise clearly brings great challenges for the judge in ensuring compliance with the legal technicalities, but also in communicating effectively to the offender, the victim, the public more widely. And I'm sure that the alien visitor and everybody else listening will be that much the wiser. So thank you very much. We're conscious of the demands on your time, particularly at the moment. So it's extremely generous of you to have delivered the lecture this year. Thank you very much.
Not at all. It's been my pleasure.
Thank you.
Thank you for the opportunity.